Be sure to share, like, subscribe, and comment down below, and make sure you turn on notifications by clicking on that bell icon. DACA should be overturned, and a new lawsuit might succeed in doing just that. A lawsuit filed Tuesday by Texas and 6 other states might finally result in the long overdue termination of the DACA program, which was created without legal authority by President Obama in 2012 to allow children brought into the U.S. illegally to temporarily remain here under certain conditions. The lawsuit does not address the question of whether allowing the roughly 700,000 illegal immigrants protected from deportation under DACA is a good policy or a bad one. Instead, the suit contends correctly that President Obama exceeded his authority under law and under the Constitution to create DACA without the approval of Congress and without taking other required steps. Now, whatever the outcome of the suit, the ruling seems certain to be appealed and will probably wind up in the U.S. Supreme Court. Now, DACA stands for Deferred Action for Childhood Arrivals. President Trump announced in September that he wanted to phase out the program beginning in March, but federal judges blocked him from doing so after lawsuits were filed to keep DACA in place. Now, the lawsuit filed Tuesday against the U.S. Department of Homeland Security in U.S. District Court in Brownsville, Texas, correctly says DACA must be invalidated because President Obama had no legal right to create the program without congressional authorization. The states contended that if Congress wants to, it has the authority under the Constitution to create whatever program it wants for the illegal immigrants affected by DACA, but the president doesn't have the power by acting alone. Now, this is a critical point. Under the Constitution, the president can't change laws strictly on his own authority just because he thinks such a change is a good idea that will benefit the nation. Congress is a co-equal branch of government and must approve new laws. If this were not the case, we would have one person rule by the president, destroying the checks and balances between branches of government that are a key part of the separation of powers in the Constitution and that safeguard our freedom. Now, the state of Texas was joined by Alabama, Arkansas, Louisiana, Nebraska, South Carolina, and West Virginia in filing the lawsuit today. In addition to lacking congressional authorization, the 7 states say DACA should be thrown out because it violates federal immigration law, was implemented without the notice and comment procedures required for all substantive government regulations and policies under the Administrative Procedure Act. It violates the Take Care Clause of the Constitution, the provision that requires the President to take care that the laws be faithfully executed. DACA essentially gives a free pass to illegal immigrants who arrive in the U.S. before turning 16 by June of 2007, granting them lawful presence with access to a myriad of government benefits, including work authorizations and Social Security benefits. The lawsuit filed by 7 states claims that DACA is just as contrary to federal law as the 2014 Deferred Action for Parents of Americans and Lawful Permanent Residents program, which is DAPA, also created by none other than President Obama. Now, the 5th U.S. Circuit Court of Appeals halted DAPA in 2015. That decision was affirmed by a divided Supreme Court when it had just 8 justices. The DAPA program gave illegal immigrants who were parents of children who were American citizens, usually because the children were born in the U.S., or whose children were legal permanent residents, of the same type of amnesty and benefits as the DACA program gave to the children brought to the U.S. illegally. But as the 5th Circuit noted, when it stopped the implementation of DAPA, letting a president exercise such power would allow the president to grant lawful presence and work authorization to any illegal alien in the United States. Texas and the other states involved in the successful lawsuit against DAPA had threatened to amend their lawsuit and claim against DACA as well. But when the Trump administration rescinded DACA, announcing it would not issue or renew DACA permits starting March 5th of this year, the states dismissed their DACA lawsuit. Now, the 7 states revived their lawsuit Tuesday to counter the errant injunctions blocking President Trump from ending DACA that were issued by the U.S. District Courts in California, New York, and Washington, D.C. In January, a California federal judge blocked President Trump's decision to end DACA. A federal judge in the nation's capital recently issued another decision that the 7 states argued took the remarkable additional step of vacating the executive's decision to wind down DACA, granting summary judgment that the wind down was substantively unlawful, and ordering the executive to continue issuing new DACA applications as well, although the judge stayed his order for 90 days. Now, in addition to all of the legal claims against DACA, the 7 states point out that the Obama administration's overall refusal to enforce immigration laws caused a humanitarian crisis. Now, the states cite a 2013 federal court decision that said that the Obama administration encouraged international child smuggling across the Texas-Mexico border because even though the federal government arrested human smugglers, it completed the criminal conspiracy by delivering the minors to the custody of their parents who were in the country illegally. Now, by promoting human trafficking, the Obama administration helped fund the illegal drug cartels, which are a very real danger for both citizens of this country and Mexico, the lawsuit filed Tuesday says. The states want the U.S. District Court to declare the original 2012 DACA program invalid. They also plan to file a motion asking the federal court to issue a preliminary injunction stopping the federal government from issuing or renewing any DACA permits in the future. The 7 states assert that their lawsuit is emphatically about the rule of law. The policy merits of immigration laws are debated in and decided by Congress, not the executive branch, which does not exercise a law-making role. So here's the bottom line. President Obama had no constitutional or statutory authority to create DACA and provide what amounted to an administrative amnesty program for illegal immigrants. It is bizarre for judges in California, New York, and elsewhere to hold that a president cannot reverse the executive actions of a prior president, particularly when they were improper to start with. It is time the courts start recognizing that. Be sure to share, like, subscribe, and comment down below and tell me how you feel about this report. But other than that, I hope you guys have a great day. Let's make America great again. Peace.